Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. Gonna go into 5 cases in depth this week and briefly touch on 2 more, including one from the U.S. Supreme Court. Yes, that's right. It is somehow Supreme Court season again. Hit me in the face like a ton of bricks. I don't know about you. And honestly, all the decisions are pretty long and complicated this week. We knew it was coming, with 2 weeks back-to-back with one decision, right? We knew it was coming. You know what else hit me in the face like a ton of bricks is the soon-to-be president's discussion of trying to end birthright citizenship. Looks like we're in for quite a fight these next 4 years. The cohesion and dedication of the non-citizens bar and its advocates throughout the legal community and outside of it gives me so much hope. I hope it gives you hope as well. Also, listen to the end of this episode. We've got a slightly new outro with a soon-to-be celebrity appearance. On to the cases. Before the deep dive cases, I want to touch on 2 of interest, to me at least. First, the D.C. Circuit issued a categorical approach crime of violence case in the sentence enhancement context this week, United States v. Burwell. Federal bank robbery in violation of 18 U.S.C. section 2113A is not a crime of violence, everyone, because it can be committed through nonviolent conduct such as extortion, and the statute is not divisible. So a few things to note there. Extortion is not violent, for example, at least not in all cases. Also, pretty good discussion of common law robbery, jury instructions and the use thereof in the categorical approach, and the Mathis peak. Doubt you'll ever have a client with this specific conviction, and you'll never be arguing it in the D.C. Circuit, but hey, keep it in mind. Honestly, I'd probably have done the case, but for the 3 publications on Friday afternoon. The second case that caught my eye, for all you employment immigration folks, is Treez Incorporated v. DHS, case number 22, Civil 07027, issued in the Northern District of California District Court. In that case, the Chief Judge of the Northern District of California upheld the broad reach of U.S.CIS's adopted decision in matter of I-Corp from 2017, that AAO decision, and determined that the agency, that is U.S.CIS, has authority to look into compliance with all federal law and illegal conduct by a petitioning employer. So not great for non-citizens. However, the district court found that the denial of an H-1B for a software engineer working for a company that targets the marijuana industry for its business was arbitrary and capricious. The court found that the H-1B software engineer, given his specific work and responsibilities for the company, could not be considered criminally aiding and abetting the violation of a Controlled Substance Act. So, Interesting to remember as our clients increasingly work for entities that directly or indirectly work with the marijuana industry. Thanks, Ira, for the heads up on that one. And those are two cases of interest, namely United States v. Burwell and Treez Incorporated v. DHS. All right, our first deep dive is Bouarfa v. Mayorkas et al., published by the U.S. Supreme Court on December 10th, 2024. This case is about the review of revoked I-130 petition approvals. KKTP submitted an amicus brief on behalf of Ms. Bouarfa. Ms. Bouarfa did not succeed in a consequentially negative holding for non-citizens, unanimously, with Justice Jackson authoring the majority opinion. Ms. Bouarfa is a U.S. citizen and wants her husband, Hamayel, to be able to remain in the United States legally and live with her. They have 3 young U.S. citizen children together. To that end, she filed a Form I-130 petition with USCIS for him so he could start the process to adjust to LPR status as the immediate relative of a U.S. citizen. And in fact, USCIS approved the petition. Under the statute, if USCIS determines that the facts in the petition are true, that is, that the marriage is bona fide, USCIS shall approve the petition. That's what they did. It's mandatory. Which quite frankly probably means that the Supreme Court would hold here that there's jurisdiction to sue USCIS for denying a standalone I-130. Surely the case actually, because there's also an exception to mandatory approval of an I-130, even where the qualifying marriage is bona fide. The Supreme Court calls it here the, quote, sham marriage bar, end quote, and under that statute, USCIS shall, again, shall, deny an I-130 petition if the non-citizen, quote, has been previously accorded or sought to be accorded an immigration benefit by reason of a marriage determined to have been entered into for the purpose of evading the immigration laws, end quote. That's the dreaded INA Section 204C. But again, because Section 204C also uses the word shall, even the Solicitor General here agreed that, quote, judicial review under the APA is available to challenge the agency's invocation of it, end quote. Put together then, had USCIS denied Ms. Bouarfa's I-130 for her husband by invoking Section 204C initially, and found that he had entered into a sham marriage in the past, Ms. Bouarfa almost surely could have sued USCIS in federal court for the denial of the I-130, and tried to prove the error of USCIS's ways. But that is not what happened, which is what makes this case so absurd. Again, recall USCIS approved the I-130 petition, but then 2 years later it revoked it under the authority of a different statute that reads that USCIS, quote, may, at any time, for what it deems to be good and sufficient cause, revoke the approval of any petition, end quote. May. Not shall. And to be fair, it's not for any reason. The INA limits the reasons that USCIS can revoke an approved I-130. But still, Congress used the word may, not shall. May revoke. It results in the exact same problem for Ms. Bouarfa and her husband for the exact same factual reason. Based on a belief that the husband had entered into a sham marriage in the past, Ms. Bouarfa's husband can now never become a lawful permanent resident through his marriage to Ms. Bouarfa because USCIS believed that over a decade ago, he, the husband, Hamayel, entered into a sham marriage. Apparently, USCIS interrogated the ex-wife who stated, quote, that her marriage with Hamayel had been fraudulent and that she had asked him for $5,000 before filing a visa petition on his behalf, end quote. Ms. Bouarfa and her husband, quote, vigorously denied these characterizations, end quote. In fact, the ex-wife later recanted her statements, saying that she had made them under duress. Seems like just the type of thing that a judge should probably get involved in to resolve, right? I imagine the couple submitted other evidence too, but USCIS was not swayed and essentially barred Hamayel from lawfully living in the United States with his family for life. So the couple sued USCIS in federal court. After the BIA affirmed everything, that is the revocation of the approved I-130, on appeal. Weird, right? For things like this, the USCIS decision is appealed to the BIA directly. But the district court judge dismissed the challenge. It held that it lacked jurisdiction. C. Under INA Section 242 A2B II, federal courts lack jurisdiction to review, quote, any other decision or action of the Attorney General or Secretary of DHS, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary, end quote. Weird, wonky language, right? The 11th Circuit affirmed the district court's dismissal. Meaning to the Supreme Court, the question before the court was whether revoking an approved I-130 petition based on a Section 204C finding is discretionary, such that federal courts can't review the issue under that jurisdiction stripping provision that I just quoted. Again, even while everyone acknowledges that the denial of an I-130 petition, in the first instance based on a Section 204C finding, would be reviewable. The Supreme Court, all of them, sided with the 11th Circuit. Revocation of an approved I-130 is discretionary, even when Section 204C is the basis, which quite frankly, it's always the basis, and it can't be challenged in federal court. The holding vacates jurisdictionally favorable holdings out of the 6th and 9th Circuits, but apparently aligns with decisions out of the 2nd, 3rd, and 7th Circuits, says the Supreme Court. The reason pretty much all comes back to the fact that the revocation statute uses the word may. The court believes that the statute is a, quote, quintessential grant of discretion. The word may clearly connotes discretion, end quote. No time limit for USCIS to revoke either. To the court, it's broad authority granted to USCIS. So broad that counterintuitively, it can't be challenged in federal court. Indeed, explained the Supreme Court, the revocation statute grants even more discretion to the government than does the companion jurisdiction stripping provision at 242 A2B single I, where only 5 forms of relief are expressly barred from review. That's the statute at issue in Patel and that whole issue, and, well, the Supreme Court believed all of it instructive. Of course, to the Supreme Court, it also means that USCIS has the, quote, discretion to decline to revoke an approval the agency previously gave, end quote, when USCIS believes that marriage fraud had occurred in the past. If any USCIS listeners can provide me an example of USCIS so exercising its discretion, the podcast and I would be most grateful. Quote, room for mercy, end quote, explains the Supreme Court. You may exercise your mercy, USCIS. You may. The Supreme Court has blessed it. Then again, quote, at oral argument, the government was unable to identify a single instance in which the agency declined to revoke its approval after determining that the beneficiary had entered into a sham marriage, end quote. So in practice, it's pretty mandatory, right? Highlighting the absurdity, the Supreme Court notes, as the Solicitor General conceded, that after USCIS revokes an I-130 petition based on a Section 204C fraud finding, the petitioner can just, quote, file another one, and if it is denied due to the agency's sham marriage determination, the petitioner can seek judicial review of that determination, end quote. Pretty wild. Ms. Bouarfa is doing just that here, by the way, and the second petition remains pending. The Supreme Court rejected Ms. Bouarfa's arguments that because Section 204C is mandatory, a revocation on that basis is too, and thereby permits judicial review. To the Supreme Court, Section 204C's mandate applies only to the initial approval or denial. Nor was the Supreme Court swayed by the fact that, again, USCIS applies Section 204C in practice as a ground to mandatorily revoke an approved I-130 petition. Nor is the Supreme Court concerned that USCIS might now abuse this power by simply approving I-130s and then revoking them so as to insulate itself from judicial review, because as the court states in a footnote, it hasn't done that yet. Rejecting a few other arguments, the Supreme Court affirmed the district court's grant of a motion to dismiss. My final thing. In a footnote, the Supreme Court, quote, assumed without deciding that Section 242 A2B applies when, as here, a non-citizen is neither in removal proceedings nor seeking review of a final order of removal, end quote. Assumes, but did not decide. That is no small thing. The inverse is essentially the last best hope of challenging decisions like this and Patel and permitting review of allegedly discretionary denials in district court when it's USCIS making the decision and the non-citizen is not in removal proceedings. The argument essentially is that Section 242 was intended, and can be read, to apply to preclude review of things that happen in removal proceedings because Congress wanted all of that to be funneled through the petition for review process, which requires beginning in removal proceedings. Patel was a removal proceeding case, but this one is not. Hamayel is not in removal proceedings, and in any case, immigration judges can't approve, deny, or revoke I-130 petitions. Most courts that have addressed the issue have held that the Section 242 bar does apply to district court challenges even where the non-citizen isn't in removal proceedings, although at least one court has held otherwise. I'm not bullish on what the Supreme Court will eventually rule, particularly given Justice Barrett's dicta in Patel, but hey, we live to fight another day, immigration litigators, scooping up those crumbs from Supreme Court footnotes where the issues are assumed, but not decided. And that is Bouarfa v. Mayorkas et al. Moving on to the BIA, with matter of Dominguez Reyes, published by the BIA. This case is about the not very often discussed but omnipresent aggravated felony, INA Section 101A43D, a money laundering offense involving a loss in excess of $10,000 to the victim. The BIA's holding is something that, to be honest, I thought was already either the law or likely the law. The circumstance-specific approach applies to the amount of loss analysis. Allow me to explain. Mr. Dominguez Reyes is a lawful permanent resident from the Dominican Republic who was convicted of a conspiracy to commit money laundering in violation of 18 U.S.C. Section 1956H. That's gotta be a top 5 federally charged offense, and it's a per se aggravated felony at INA Section 101A43D that makes a LPR lose their green card, so long as the loss to the victim exceeded $10,000. In Mr. Dominguez Reyes' case, the federal judge ordered a criminal forfeiture of nearly $4 million. But forfeiture doesn't necessarily equate to victim loss, and DHS has the burden on removability to establish that there was over a $10,000 loss to a victim or victims. DHS met that burden, said the IJ, and now the BIA said it as well. Mr. Dominguez Reyes' attorney's argument was that the IJ shouldn't have been able to look at the criminal forfeiture order, and that instead, the IJ was limited to reviewing only the classic categorical approach documents, like the plea agreement, criminal charge, formal judgment of guilt, that kind of stuff. The problem is that in U.S.C. v. Holder, the Supreme Court essentially created the circumstance-specific approach and permitted IJs to look beyond those documents to other reliable criminal documents to determine the amount of loss for the very similar aggravated felony provision at INA Section 101A43MI, which also requires a showing of victim loss in excess of $10,000. Here, the BIA held that Nijuan also applies to Section 101A43D's victim loss analysis. To the BIA, this is because, like with Section 101A43MI, whether, quote, the amount of funds exceeded $10,000 does not refer to a generic category of crimes or indeed any crime at all. It instead describes the specific way in which an offender committed the crime on a specific occasion, end quote. Looks like the 5th and 9th Circuits have already held as much directly in regards to Section 101A43D. So the BIA is not breaking totally new ground. The BIA reasons that because the loss amount is not an element of a money laundering offense, quote, if we were limited to the categorical approach, no conviction under 18 U.S.C. Section 1956 would ever be an aggravated felony under Section 101A43D, notwithstanding the express reference to that criminal statute. We normally do not construe statutes to be inoperative or superfluous, even in part, end quote. Remember that quote, though, when we're about to talk about the aggravated felony rape definition and matter of Keeley in the next decision. Anyway, so what can the BIA consider during its circumstance-specific approach analysis to determine the amount of loss? Well, ever expanding the realm, the BIA states, quote, we are generally free to consider any admissible evidence, end quote. Admittingly, quoting from the very non-citizen, rough decision Oriana v. Mayorkas, episode 66. And in matter of FRA, episode 93, the BIA held expressly that the circumstance-specific approach permits consideration of a federal forfeiture amount ordered, so long as, quote, the proceeds received are sufficiently tethered and traceable to the conduct of conviction, end quote. Restitution orders are likely similar, explains the BIA in past precedent, and here, if sufficiently tethered to the conviction. So tethered here, quote, the forfeiture order specifically identifies the amount that was directly attributable to the respondent's personal conduct, end quote. If it hadn't been, though, and if it was just a general forfeiture order split across a bunch of defendants, DHS might not have been able to meet its burden, even under matter of FRA. So remember that. Here, though, and at least with what the BIA is reviewing, Mr. Dominguez Reyes, quote, is the only defendant named on the forfeiture order, end quote, which again is nearly $4 million. And oh, by the way, criminal documents submitted by a DHS officer with a sworn statement from DHS attesting that they are true and correct copies of electronic records suffices to certify criminal documents for immigration purposes under the regulations, explains the BIA. All of it means that Mr. Dominguez Reyes is removable and ineligible for the only form of relief that he sought, LPR cancellation of removal under INA Section 240A. And that is matter of Dominguez Reyes. Next is Quito-Guachichulca v. Garland, published by the 8th Circuit on December 9th, 2024. This case is about aggravated felony rape offenses at INA Section 101A43A. Mr. Quito is a lawful permanent resident. 16 years after becoming one and having not naturalized for reasons unexplained, he was convicted of third-degree criminal sexual conduct in violation of Minnesota Statute Section 609.344, Subdivision 1D. ICE initiated removal proceedings alleging that this crime matches the federal definition of rape used at INA Section 101A43A, thereby making it an aggravated felony and thereby making Mr. Quito removable. An immigration judge and the BIA agreed, but the 8th Circuit very much did not. Because the categorical approach applies, of course, quote, which requires us to examine the nature of the conviction, not Mr. Quito's actual conduct, end quote. That, of course, requires figuring out what the generic federal definition of rape is, as used at this aggravated felony statute, and then applying the elements of the least culpable conduct criminalized by the Minnesota offense to it. If Minnesota criminalizes more or not as bad conduct, then you do not have a categorical match, and you likely don't have an aggravated felony. Now, the BIA has told us all what it believes the generic federal definition of rape is. But after Loper-Bright, that decision, matter of Keeley, and deference to it, quote, is now a relic of the past, end quote. The BIA's view of statutory definitions is no longer, quote, even especially informative, end quote. Oof. So really just brushing right past matter of Keeley, the 8th Circuit starts with the elements of the Minnesota offense. Not my preferred categorical approach route, but let's do it. And I apologize for having to discuss the elements of a crime like this, but it is a rape case. Apologies again. Just putting it out there if you want to skip. Pertinently, the Minnesota offense permits conviction through digital penetration. That is, a defendant using something other than his or her sexual organs like, quote, fingers or an object, end quote. Pretty bad stuff, and a jury in New York found in the civil context that the former and incoming president did just that in New York many years ago. But as with the former incoming president, there's lots of case law that explains that technically that's not rape. Sexual assault, of course, but not rape. So, does the generic definition of rape, as used in the INA, include digital penetration of the sort that the incoming president was found civilly liable for having done in New York? Well, as the 6th and 5th Circuit have already held, quote, as counterintuitive as it may seem, when rape was added to the list in 1996, the answer was no, end quote. That is the list of aggravated felonies. Again, sorry for the language and discussion and stuff, but there is no avoiding it. Webster's dictionary defined rape at the time as requiring, quote, penetration of the vagina by the penis, or at least genital contact between individuals, end quote. Black's Law Dictionary and other dictionaries did as well. So did Brian Gardner's book, Justice Scalia's friend and a, quote, source that the Supreme Court has deemed reliable for this purpose, end quote. How about that? The 8th Circuit then proceeded to see how the states defined rape in 1996. An analysis that the Supreme Court did in Esquivel-Quintana. And well, quote, of the 23 states that had an offense called rape in 1996, only a handful included digital or mechanical penetration, end quote. This constitutes, quote, strong evidence of its common contemporary definition, end quote, at the time. That is, rape. And it didn't include the digital or mechanical penetration. Not only all of that, but as I'm arguing in an 11th Circuit petition for review literally right now, and as the 6th Circuit reasoned in Keeley v. Whitaker, quote, perhaps the strongest evidence comes from the list of aggravated felonies itself, end quote. Section 101A43A lists as an aggravated felony a crime that is, quote, murder, rape, or sexual abuse of a minor, end quote. And while, quote, the back-to-back references to rape and sexual abuse suggests that the two terms are distinct, neither surplusage of the other, end quote. That is, rape can't be sexual abuse, right? Because the exact statute literally includes sexual abuse right after rape, and only makes it an aggravated felony when it's committed against a minor. Quote, why pair rape with sexual abuse unless the idea was to cover fewer crimes against adults than against minors, end quote. Again, all important because the 8th Circuit sees digital or mechanical penetration as sexual abuse and doesn't see rape as including sexual abuse. Quote, sure enough, Congress had already been distinguishing between the two for some time, beginning at least a decade earlier when it replaced the federal crime of rape with multiple sexual abuse offenses, end quote. The 8th Circuit reads Congress as having done this to expand the conduct it criminalized federally, that is, by using the term sexual abuse elsewhere in its statutes, but Congress still kept simply the term rape at INA Section 101A43A, at least when it applies to adults. The 8th Circuit rejected the same argument that Oil is making in my petition for review. Quote, the government seems to think that the recent name changes at the state level for these types of crimes helps its case, not hurts it, end quote. That is, that, quote, all of these words and phrases, rape, sexual abuse, and criminal sexual conduct, are interchangeable, with each encompassing object digital penetration in the rape-analogous rape statutes, end quote. But the 8th Circuit is not swayed. The INA doesn't use the word, quote, analogous, end quote, explained the court, and, quote, adding words to unambiguous text is rarely the answer, end quote. Quite frankly, the 8th Circuit doesn't believe the government's survey of case law describing rape-adjacent statutes from the states in the early 1990s is helpful at all at really figuring out the generic definition of this specific term, that is rape, used in 1996. I cannot stop at this point because, again, I'm literally litigating it as we speak. Quote, what the government is essentially asking us to do is agree that certain analogous state crimes must count as rape and then reverse engineer a definition to make sure they do, end quote. But that's not what statutory interpretation is supposed to do, explained the 8th Circuit. That's for Congress to do, that is, define its terms. Finally, reasoned the 8th Circuit, maybe sexual assault is a removable crime involving moral turpitude? It probably is, to be honest, and so, quote, it substantially weakens the argument that Congress unintentionally left a gaping hole in the statute, end quote. The 8th Circuit concludes its discussion by recognizing that the categorical approach wasn't quite like it is today when Congress added rape in 1996, and maybe if Congress had known how, quote, topsy-turvy, end quote, the categorical approach is, they would have used a different phrase. But they didn't, so the government loses. Quote, unless and until it does, the aggravated felony version of rape excludes digital and mechanical penetration, end quote. The Minnesota offense is not an aggravated felony. Big stuff and a big win. So thank you, unnamed counsel, on these 8th Circuit Day of Decisions, and the named National Immigration Project of the National Lawyers Guild for amicus on behalf of petitioner. But don't worry, I reached out to the guild. Big congrats to Nadia Anguiano and Siko Shastri from the University of Minnesota Law School. If that wasn't all confusing enough, here's some more discussion on res judicata. So, although Mr. Quito won the day, the 8th Circuit held first, actually, in this decision, before it got to all that categorical approach stuff, that res judicata didn't bar ICE from making the INA Section 101A43 aggravated felony allegation on remand. See, in fairness to ICE, and I'm always fair, ICE had originally alleged that the conviction in this case was a crime of violence aggravated felony as defined at INA section 101A43F. And it probably was. But the charge became untenable after the Supreme Court's decision in DiMaia that held that half of the underlying crime of violence definition, 18 U.S.C. section 16B, is unconstitutionally vague. The Eighth Circuit then sent the matter back, and that's when ICE changed their aggravated felony allegation to INA section 101A43A, something that they of course could have brought the first time around if they had wanted to. That's why res judicata might apply. But not only is the Eighth Circuit, quote, unclear whether the doctrine applies in immigration proceedings, end quote, but even if it did, it doesn't apply to this case, explained the court. That's because at a minimum, for the doctrine to apply and thus bar a party from litigating something new against another party that could have been brought the first time around, there must exist a, quote, final judgment on the merits, end quote. While the removal order in this case indeed became final when the BIA first ruled, it lost, quote, whatever finality it had once we vacated and remanded, end quote. When the circuits remand these type of cases on the podcast, the agency's order is no longer final. And so, quote, no finality, no res judicata, end quote. Fair enough. But quite frankly, this INA section 101A43A holding is a bigger win for non-citizens than would be a favorable res judicata finding. And that is Quito-Guachichulca v. Garland. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Concluding with two from the First Circuit first. Manzali-Bopaka v. Garland, published by the First Circuit on December 13th, 2024. This case is about credibility. Mr. Bopaka is from the Republic of the Congo. For those not in the know, that is separate from the Democratic Republic of Congo, which is probably what most people think of when they hear the Congo, at least I do. But this is the Republic of the Congo, next door. Mr. Bopaka's asylum claim was based on his asserted membership in the particular social group, quote, direct family members of Mr. Sebastian Manzali, end quote, his father. An immigration judge denied based on an adverse credibility finding, and the BIA affirmed. The BIA then refused to grant a motion to reopen for submission of new evidence, and it would appear another motion to reopen that was based on asserted claims of ineffective assistance of counsel against prior counsel. All are now before the First Circuit. The First Circuit affirmed the agency on all matters. Now it is true, explained the court, that the credible testimony of an asylum applicant can win the day on its own, nothing else, if it's credible and sufficiently persuasive. But on the flip side, an adverse credibility finding is alone sufficient to deny, and in any event, the quote, absence of easily obtainable corroborating documentation can be the final straw, end quote, with such cases. Here, the First Circuit saw a record and testimony, quote, replete with inconsistencies and omissions, end quote. Mr. Bouarfa's initial asylum declaration explained that his entire family was murdered by the current president of the Republic of Congo for their political involvement, and that he too was threatened. He testified in court, however, that he was arrested, an omission from his declaration. Pesky declarations. Also, he checked no to the question in the asylum application about ever having been arrested, so that's really two opportunities to bring up the arrest that he did not do. And actually, he said in that application as well that he was, quote, almost arrested, end quote, in 2018. Very different from a 2016 actual arrest that he testified to. Perhaps that's one of the reasons he alleged ineffective assistance of counsel later on. He also omitted in his application the circumstances of his flight from the Republic of the Congo, which itself is a bit of a harrowing story, explained the First Circuit, and it supports an adverse credibility finding, that is, the omission. Moving on, a pretty big inconsistency to the court was the next discrepancy, the claim that his father was an attorney and farm owner, but the death certificate submitted said that the father was a chauffeur. It also appears that on the stand, Mr. Bouarfa may not have been truthful about having a son and who the mother of that child was. In light of all of this, the IJ didn't need to believe Mr. Bouarfa's story, explained the court, particularly as Mr. Bouarfa appears to have not submitted additional important evidence, like a corroborating letter from the brother he apparently came to the United States with. The adverse credibility finding tanks a withholding of removal claim too, and while it doesn't necessarily preclude Convention Against Torture Protection, it usually does and did here. It was the same basis after all, and Mr. Bouarfa did not present lots of independent evidence supporting his claim that didn't rely on his own credibility. On to the motions to reopen then, where Mr. Bouarfa tried to submit additional corroborating fact and expert evidence. Even if this evidence was new and previously unavailable, and it doesn't seem like any court thinks it is, it doesn't have much to do with the adverse credibility finding reasoned to the First Circuit, and so was unlikely to change the IJ's decision, even if remanded for consideration. Simply put to the First Circuit, quote, none of Mr. Bouarfa's submitted evidence in support of his motion to remand undermined the reliability of the evidence underlying the IJ's credibility determination, end quote. Even if it somewhat corroborated his claims and showed how bad conditions are for many people in the Republic of the Congo, if you've got an adverse credibility finding and you want to remand or reopen for consideration of new evidence, you probably have to deal with that credibility finding first. As I mentioned, there do appear to be two motions to reopen here. That first one was for submission of new evidence, but the second one was based on ineffective assistance of counsel claims. And the claims appear serious. In addition to submitting an allegedly, quote, shoddy, end quote, asylum application, it was alleged that Mr. Bouarfa's prior attorney said in a termination letter that I guess somehow made it into the record that Mr. Bouarfa had, quote, not produced any independent and or objective evidence to corroborate your claim of fear, end quote. That's pretty bad to get into the record. And apparently the prior attorney submitted poorly translated documents as well. Articles that, if properly translated, apparently would have shown that the father is indeed political. But even assuming these exist, the First Circuit still saw other inconsistencies, independent of the errors that the prior attorney allegedly made. The court appears very much not to want to remand this matter, and so it did not. You might only get one shot to pursue asylum in this country, and the record starts developing at the U.S. border. Be prepared, asylum seekers, and choose your counsel wisely, if you have the means. And that is Mandazali Bouarfa v. Garland. Meaning that we conclude with Lopez Quinteros v. Garland, published by the First Circuit on December 13th, 2024. This case is about mixed motive particular social group asylum cases, and most pertinently, family-based claims. Mr. Lopez and Ms. Polanco are both petitioners in this case and refer to each other as husband and wife. They also share a minor child who is also a part of their removal proceedings. They're from El Salvador and testified in immigration court that they feared returning to that country because of their membership in the particular social group of, quote, business owners, end quote. That is Mr. Lopez. And Ms. Polanco and the child feared returning because of their membership in Mr. Lopez's family. They feared the gangs in El Salvador. An immigration judge and the BIA denied their claim based on a no-nexus holding. The petitioners brought many arguments to the First Circuit, and the First Circuit doesn't really provide a factual background section of this decision. I shall therefore go through the claims one by one, getting into specific details as I progress. First, the First Circuit rejected the argument that a remand was required to clean up the record, even though there were quite a few, quote, indiscernible, end quote, notations in the transcript from the IJ level hearing. And that is because the non-citizens didn't raise that issue to the BIA, so it was not exhausted. Nor does the First Circuit believe that the agency's mixed motive analysis was flawed. IJs and the BIA, of course, must consider whether there are multiple motives for persecution and whether a potentially protective ground is one of the motives and is at least one central reason for the persecution, even if it exists alongside a non-protected ground. But at the First Circuit, there's no indication that the agency failed to conduct this analysis. The IJ's transcript mentions the business owner thing, even assuming it viable, but saw that the case was more of a simple extortion case. The First Circuit essentially held that the IJ did enough to consider the asserted nexus to a particular social group with the language that the IJ used. Business owners was considered and rejected, explained the First Circuit. Nor did the First Circuit believe that the BIA erred in reviewing the IJ's no-nexus finding for clear error rather than de novo. Quote, the BIA expressly recognized that the clear error standard of review applied to the IJ's factual findings and that the de novo standard applied to all other issues, including issues of law, discretion, and judgment. End quote. So I guess the First Circuit is saying that initial facts, such as the reason for harm, are reviewed as factual questions, but whether those facts satisfy the nexus standard is reviewed as a mixed question of law and fact de novo? So like a two-step review process? The court is far from clear here, but it seems that that's what they're saying. Then again, the court says elsewhere in the decision that, quote, the determination of whether the nexus requirement has been satisfied is one of fact, end quote. So I'm not sure what's up here. I'm sure it'll be explained in future decisions. However, that the IJ conducted the analysis and that the BIA reviewed it properly doesn't mean that they reached the correct conclusions. And everyone agrees that the gang targeted Mr. Lopez because they wanted money, as gangs are apt to do, and which asylum law has developed not to protect, for reasons that we can debate off podcast. Those related holdings by the agency, well, the First Circuit saw no error there either. To the court, Mr. Lopez, quote, introduced no direct evidence that the gang's threats had anything to do with his business owner status, end quote. Even if he pointed to country condition evidence about how it all happens in El Salvador and how business owners are targeted, and even if the gangs only started targeting him when he began operating a business. Asylum law really doesn't want to protect extortion. But a remand is still coming, and Mr. Lopez can thank Ms. Polanco for it. Because even if Mr. Lopez doesn't have a claim, Ms. Polanco brought her own claim based on her membership in his family. That's a separate possible particular social group. Indeed, quote, there is no question that a family unit constitutes a particular social group as the agency recognized, end quote. Even if they weren't technically married, by the way. The record shows that when the extortion against Mr. Lopez didn't work, the gang started targeting Ms. Polanco and the couple's child, threatening to kill them. Quote, credible death threats can amount to past persecution, end quote. And while they may have been doing it to get Mr. Lopez to pay extortion, the gang was pretty clear that they were targeting Ms. Polanco and the child because they were Mr. Lopez's family, not for any reasons particular to them. And this is where the decision starts to get interesting. As the First Circuit puts it, a viable family-based particular social group claim can lie even if it was the, quote, actions of the other family member, rather than merely the family status of the petitioners, that precipitated the claimed persecution, end quote. Love that well-said quote. Look no further than the First Circuit's cattle thief case, Pineda-Maldonado v. Garland from episode 196. Explain the First Circuit. Podcast citation and all. One central reason doesn't mean the only reason. On this record, Mr. Lopez's, quote, action in not paying off the gang alone explains the gang's choice to threaten Miss Polanco in particular, end quote, and that suffices for family-based nexus in the First Circuit. Take note. By the way, this remains the case even though, quote, all indications are that gang members would have stopped threatening Miss Polanco and the child if Mr. Lopez had paid off the gang, end quote. This is becoming a stealthily powerful case, not least of which because Mr. Lopez is surely also a derivative beneficiary of Miss Polanco's claim, or maybe he can become one if they legally marry before remanded immigration court proceedings. Just saying. If it's all a bit confusing, don't feel bad. Here's this standard of analysis to use in your case. Quote, whether the alleged persecution is family-based ultimately must depend on the extent to which the record shows that the family status of the targeted person drove the decision to target that person as a means of obtaining money that the targeted person had no legal obligation to hand over. End quote. Does that help? And whereas here, where the, quote, persecutors made a point of emphasizing the target's familial ties to the person that they were extorting, end quote, and where there was no other apparent separate reason to target the family members, like they didn't even want money from Miss Polanco, you have a likely claim. The First Circuit believes its holding aligns again with prior First Circuit precedent and a Fourth Circuit decision from 2015, Hernandez-Avalos v. Lynch, and a Seventh Circuit decision from 2019, Gonzalez-Ruano v. Barr. The 11th Circuit is a bit all over the place, if you're wondering, explains the First Circuit in a footnote. The court goes on to distinguish some of its other prior precedent and other precedents from other circuits, and Judge Kayata dissented on the remand. But that's only one judge. Remand for Miss Polanco's family-based asylum claim for further nexus and past persecution analysis. But with this decision, I'm not sure how the agency can find nexus, at least, unsatisfied. How about that? As such, congratulations, Christian R. Meyer and Kevin P. McMurray for the petitioners. And that is Lopez Quinteros v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetseli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.